Of course, you have heard about this ART tribunal bill being passed where you don't have to conduct the oral hearing from various media outlets and from my peers and industry people. Today, I'm here to discuss about the positives and negatives of these particular changes, just so that you are fully aware about it. Hi, this is Nish from Professional Visa and Education Services, immigration lawyer, and also Director of Professional Visa and Education Services since 2015. Today, I'm here to discuss about your positives and negatives of these particular ART changes. As a student visa, if you have a student visa refused, at this point in time, the bills basically just talk about the student visa. Well, there are particular other temporary visas that is also talked about, but at this point of time, it appears that it will mainly just impact the international student visa being refused at the Department of Home Affairs and who has applied for the review at the Administrative Review Tribunal. What the positives is, if your visa has been refused with the minor human errors from your agents or migration agents, especially, they forget to upload your financial documents, or you have not done your medical test, or they're missing out the English test, well, simple evidentiary requirements were missing when the application was lodged. Well, this can be tackled quite easily. Well, in fact, we were previously tackling with the tribunal in this situation by simply supplying those evidence and requesting tribunal member to expedite the hearing. So, but now this is more evident that you can provide all of these minor human error documents during the submissions, and then you can request the tribunal member to make a decision based on that. Now, the negatives is usually, with my experience, is when we go out there on a hearing date, it really depends on the tribunal member as well. You could be writing really good submissions about how this person really deserves this visa, but again, there are certain aspect of the visa component that the tribunal members, depending on the members, would like to assess further. Despite you might not have a lot of perspective arguing the tribunal previous decision of the Department of Home Affairs purely based on regulations and policies and schedules, but some of the tribunal members would like to go beyond that, which means they would like to take some oral submissions from you as well. And there has been many instances where we have presented the case, we have talked about the compelling compassionate situation, we have been able to convince the member that this applicant were genuinely in trouble when he was on a student visa, and we were able to provide some oral submissions, even oral declarations in front of the tribunal members. We have had the positive outcome. Now, just submitting all those documents in a paperwork and not being able to see the member face to face, I personally think it's a bit of a disadvantage for the applicants, not being able to articulate and express everything they have gone through during their stay in Australia. So I think it's a huge negative. But in terms of positives, the only thing is that some of the applicants might be quite nervous and skeptical when it comes to the tribunal matters. They feel like this is the environment that they've never been exposed before. But especially, it's a good news for those ones who's quite nervous being in front of a member and trying to explain things properly in person. Well, now they don't have to face this environment because the application can be decided just with the submissions. As a lawyer, me personally, am I happy with this particular bills? Probably not, because there are many instances that we've been able to convince the member during the day at the oral hearing, because we have noticed that many times that we can think about every possible scenario in the submissions, but it also depends on the member. Member might have different questions, which is kind of outside of the box, and usually this conversation is very impactful to convince the member about your client, who your client generally is in terms of their personality and everything like that. So I think it's a bit of a loss. Why they're doing this? Of course, everyone knows this. There's a huge backlog in tribunal when it comes to the student visa refusals. By default, people will usually go and challenge these cases at the tribunal. Even before the bill's been passed, there has always been this particular section in the application where you can tick the box and say, well, I would like member to make a decision based on the evidence that we have provided. But usually we would like to tick that, we would like the oral hearing before these decisions are made. So in terms of the industry people, I don't think lawyers and migration agents are generally happy about this particular legislation. But when it comes to expediting the process, when it comes to winning the case, with where there has been a minor error by the previous agents or lawyers. This is a really good avenue. We can expedite the process. But generally, I don't think not having not having the chance of proper oral submissions also opens up a few more jurisdictional error, which obviously further can be challenged in a federal circuit court. But I hope this will clarify the position as a client and position as a lawyer about these particular changes with the ART. Again, I'll be back again with more news and update if there is any changes in this area. But thanks for watching. Thanks for following. Keep sharing and keep watching with your friends and family. I'll be back again with more news and update. This is Nish from Professional Visa and Education Services.